And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retaining rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out?
Welcome back to your favorite YouTube channel. No one is above the law. Today we have a pretty wild courtroom appearance. Some pretty far out there arguments from a sovereign citizen, a young lady in the courtroom of Judge Warren Davis. I want you guys to hear what she has to say. I want you to hear the judge's response. And I want for you all to give your comments down in the comment section. What you think about this case, how you think the judge handled it, and what do you think of some of the things that this young lady is saying in the courtroom? Do you think she should get a competency evaluation if she haven't had one already? Or do you think she's just playing around with the court? But with that being said, guys, let's go ahead and roll the footage.
All right, then we will go to Ms. Celestine's case. We will let the state be able to set up. There's very important issues today. Now we were on this, well, just set the case up and then it's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Celestine, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Celestine would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. An examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in compelled bond. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol. And that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest made that was September 16th, 2025.
right? So after the time she failed to appear in the court, did she have any other arrests other than this traffic offense?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the benchmark was outstanding. So we would submit to the court that based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition she would just ignore. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Everything. Yep. Thanks.
Yeah.
The address I'm showing is 2214 Upper Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Celestine, that is the issue before me is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she's saying that she won't have to come out, so I will bring her to you in person.
Okay, so she says she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, if she'll come out, I mean, I'm glad to hear it. It's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's in. Got it. Is it?
No, it's not. He has to.
All right, Celestine is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authority to court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
And you have a right to be heard on those issues, because that's the matter
Right.
right now.
Okay.
If you don't want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
Well, first, the bond is excessive, and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia.
All right. You see what just happened? The judge clearly laid out the 4 bond factors: flight risk, risk of committing future felonies, possible danger to the community, and witness intimidation. Listen, he simplified it for her. He told her exactly what she needed to address, and instead of responding to the actual bond criteria, she goes straight into sovereign citizen script mode. Article this, paragraph that, natural rights, birth rights, treaty rights. None of that addresses the fact that you were gone for 2 years on a bench warrant. This is what I keep telling you guys. when you focus more on internet rhetoric, and, you know, I don't want to assume maybe she didn't get it from the internet. Maybe, you know, somebody's out there selling some type of booklet or whatever have you. But when you focus on whatever it is, more than the actual legal procedure, you miss opportunities that could actually help you. The judge even told her she would likely pass 2 of the 4 factors. That means she had a real opening here. But when you don't acknowledge the authority of the court, you can't simultaneously expect relief from the court. You can't have it both ways. And now she's digging herself deeper because she refuses to answer the only question that matters right now. Are you a flight risk, and are you a danger?
And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retained rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to God. Now we're back on.
I did give you Article
the 2 bond conditions, yes or no.
I gave you Article 1, Section 1, Paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, Amendment 8, I should not be held under false imprisonment, under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. Just something else you're wrong about. But anyway, ma'am, I'm once again sad.
Can I judge this comment please post it on the record?
This is where I'll have you removed, because right now.
You might as well. That's fine. I don't care.
That's fine. But ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything to pay.
That's fine.
So
well, it's not for me because I'm not I'm here with the defendant.
All right. Take care, ma'am.
Under be correct.
Make different decisions. All right. Take care.
Okay, there it is, guys. Bond revoked. And if you notice something, the judge didn't revoke it because of her constitutional speech and all of the things she had to say while she was at the jail or in the courthouse. He revoked it because she refused to respond to the bond factors. That's it. The state met his burden. She didn't rebut it. And that's how procedure works. This is a perfect example of self-sabotage in real time. We all watched it. The judge even said she probably would have cleared, once again, 2 of the 4 categories. That means she had a fighting chance, but instead of addressing the 2 that hurt her, flight risk and danger, she went back to the same recycled arguments about not being compelled to pay bond before conviction. And now, ironically, she got exactly what she claimed she wanted. She doesn't have to pay bond anymore because she doesn't have one. This is why I always say believing you're right is not the same thing as arguing effectively in court. Courtrooms operate on legal standards, not personal ideology. You guys hear me say that all the time. And when you refuse to engage with the actual legal framework, the consequences are very real. That's all for today. As always, thank you guys for joining me here on No One is above the law.